Hello, my name is Rob Sterne, and I am with the intellectual property specialty firm of Sterne, Kessler, Goldstein Fox in Washington, D.C. It is March 2014, 18 months since the America Invents Act new contested proceedings became operational. I am the editor-in-chief of Patent Office Litigation, the first and what many consider the definitive treatise on the new patent enforcement, licensing, and monetization world in the United States. So much has changed in this world in 18 months, and the rapid change continues. If you are a patent owner, an individual inventor, an investment group, R&D lab, startup, emerging company, university, government agency, or larger enterprise with underutilized patents and are trying to enforce, license, or monetize these valuable property rights and assets, please consider what I have to say in this video before, and I repeat before, you begin or continue your program. There are 6 topics you need to know to be effective in this new patent world. First, radical and fundamental changes in your patent business model have occurred. It used to be that the patent owner would send out demand letters or file court suit and then rapidly settle for license fees commensurate to the perceived infringement value. This is no longer the case in most cases, regardless of the technology, the type of patent owner, the type of accused infringer, or the amount of money involved. Do not be blindsided or surprised by this big financial change. Second, before September 16, 2012, the date the new contested proceedings became operational, seldom would the potential licensee or accused infringer go to the United States Patent and Trademark Office and challenge the validity of the patent in question. The prior procedure for such a validity challenge was considered problematic for success by the potential licensee or accused infringer community. These proceedings were too long, often 5 to 10 years for completion, too uncertain for success in invalidating the patents. Usually the court hearing the infringement suit would not stay its proceeding until the validity challenge at the patent office was completed. And if invalidation of the patent at the patent office did not occur, this would prevent the potential licensee or accused infringer from raising the same or similar invalidity defense in the court suit. So most of the time, the court suit would continue to settlement or completion without an invalidity challenge of the patent in the patent office. But the new contested proceedings, 3 are pertinent: inter-party review, the covered business method proceeding, and post-grant review, have changed all of this. Third, these new validity challenge proceedings at the patent office must, and I repeat, must be completed by statute within 1 year of institution of the patent office patentability trial. Along with the preliminary period before the institution decision is made by the new Patent Trial and Appeal Board, these proceedings must be completed within 16 months from filing. And there is only one appeal to the United States Court of Appeals to the Federal Circuit, making the whole process from start to finish only 2.5 to 3.5 years in length, much faster than the prior invalidity challenge proceedings. Fourth, the cost of bringing one of these proceedings by the potential licensee or accused infringer is between $500,000 and $1.5 million US for the entire process through the Federal Circuit appeal. This price tag must be compared to the defense of a patent infringement suit in the courts, which typically cost $2 million and up. Some success in these patent office proceedings, or since success in these patent office proceedings, can extinguish the infringement charge, many potential licensees and accused infringers are taking advantage of these new proceedings. There have been more than 1,000 of them filed since September 16, 2012, and the rate of filing continues to go up. Additionally, more than 80% of these proceedings involve parallel litigation in the courts, and around 75% of the patent claims challenged in a filed proceeding are instituted for patentability trial at the Patent Trial and Appeal Board. And the success rate for the challenge claims, based on the several dozen of proceedings that have been completed to date by the new Patent Trial and Appeal Board, is low. So these new contested proceedings pose a very real and radical threat to patent owners of all types. Fifth, historically, patent owners have had to use trial attorneys who take their cases on some type of contingency arrangement. Typically, the patent owner would not have the financial resources to bring the suit using its own money. And often, the patent owner wanted the trial attorney to have an alignment of interest in winning the suit. But the defense of these new contested proceedings must be successful. Otherwise, the patent is invalid and the entire patent licensing, enforcement, and monetization program is destroyed. Contingency trial attorneys have been slow to recognize the high probability that a proceeding at the patent office will be brought by the potential licensee or accused infringer. They typically have not built the cost and time of defense of one or more of these proceedings into their business model of successfully winning the lawsuit. Sixth, and most importantly, as an attorney who specializes in these new contested proceedings, currently I and my firm are involved in over 100, which may be more than any other firm in the United States. And as an attorney who defends many famous patent owners, I can tell you from extensive professional experience, spanning thousands of hours of work in these proceedings, that the patent trial bar usually does not understand this threat or properly take it into account. And I have seen very valuable patents get invalidated because trial counsel hired inexperienced contested proceedings counsel, or counsel who were on a budget that did not allow for a full, effective, and comprehensive defense of the patent. As the patent owner, you must be aware of this very significant threat to your ultimate success. Make sure your budget for one or more of these proceedings is adequate. Determine how to mitigate the very real downside risks, and staff the defense with the most experienced and effective contested proceedings counsel you can hire. Otherwise, as many patent owners have discovered over the past 18 months, your entire business model is destroyed by one or more of these contested proceedings, even if your trial counsel is successful in the parallel court suit. Thank you very much for your time.